bottom of this is the tension between the need and the desire to move forward expeditiously. I understand, I think the word cumbersome was used by the staff in their presentation. I understand it's cumbersome. Due process is cumbersome. But there's a tension between wanting to move forward quickly and the need to give people their constitutional rights to be heard. And that's really what's going on here. And I think NACWA is very concerned that in the desire to protect the fish and to do something that clearly your staff believes is important, that we not disregard due process rights. So the question is, what does NACWA think should happen here? Well, what we think should happen is the board should initiate a quasi-adjudicatory process. And either that can be done through an action in Superior Court, or it can be done through an action here before the board. You can order an immediate evidentiary hearing. You can give everyone their right to be heard. You can give everyone the right to cross-examine. And at the end of the day, the chips will fall where they may. And if Mr. O'Loughlin and his clients can prove that the proposed approach here is not viable, not the right way to go, then they'll prevail. And if they can't prove that, then the board will do what the board will do. So that's what we think should happen here. Be happy to answer any questions.
Thank you.
Thank you.
Jim Edwards?
Good afternoon, board members. Thank you for hearing me. I'm pretty proud of my nephew here. We're a family operation. We have riparian and pre-14 rights on Antelope Creek, and the water's been diverted there since prior to 1870. Up until about a week ago, I felt fairly secure in my water rights. I felt that I had senior water rights. I had read that junior water rights were in jeopardy, but I felt fairly secure. Then I learned about some regulatory encouragement and the opportunity to volunteer to sign agreements. And yesterday we did sign an agreement. And we're trying to volunteer. During that period, we did a voluntary pulse flow on the stream, hoping that that might draw fish up the stream. I haven't seen the details of that yet, but the whole stream was diverted down the whole stream was, the free flow exited the stream. And the base flow requirement is 35 CFS on Antelope Creek. And as my nephew mentioned, previous dry periods it was 34. So obviously the whole stream is going to go down if this regulatory process is taking place. We will lose our water. As Tyler mentioned, we have about 1,400 head of cattle out there to worry about, and if this goes through, we'll be told that we can't irrigate out there, and we're going to have to figure out what to do with our cattle. There's about 700 acres that are irrigated by Antelope Creek that we rely on. It would turn dry. Over the years, we've invested miles and miles of cement ditches to make efficient operations. In the last 2 years, we put in about 3,400 feet of pipelines to replace dirt ditches. We're doing our best to make the best use of this water. We know it's scarce. And we do want to protect the fish, and but we want to try to survive. So I think one other sidelight that I might throw in here to consider is that up in our area, 70% of our water supply is coming from the ground. And what little remains of our surface water access is in these creeks. And that recharges our groundwater. Now, if we lose that water, we're going to have to pump, which is going to jeopardize further our groundwater levels up there, which are already stressed and already reaching critical conditions. I think I'll leave it at there. Thank you.
Thank you. Yes, go, sure.
Just to help me get this in, thank you very much. I just turned it off. Can you explain to me if, for example, they're in a voluntary agreement that they've agreed to? As I read this, there's the exemption, so they wouldn't have to give up more water, or would they? I'm just getting a little confused with the comments versus what I read.
Yeah.
And I apologize for not being here for the presentation. I had reviewed it, but that's not the same as hearing it.
So the voluntary cooperative solution section is, we think, going to cover a lot of situations that people will have. Before I get back to this particular question, it sounded before like somebody was suggesting that voluntary cooperative solutions could only happen for one individual diverter. It seems like so far they have, but there's nothing preventing larger groups of coordinating as well. And really what the way the proposed regulation is crafted right now is a voluntary cooperative solution that the fisheries agencies have agreed to with a diverter or diverters would, if approved by the deputy director, not require that diverter to have to comply with the minimum stream flows that are set out in the other section. So if you have a voluntary cooperative solution or agreement that's brought to us, the deputy director can approve that, and that will do it. There's no and situation. You have to do both. Does that answer your question?
I think so. I think so. So what that would mean for these gentlemen is if they're in something that they've already agreed to with the fish agencies, which is more real time versus the whatever you call the blows in there, I don't want to presume to call, then they're not going to get called on for more. Is that what the agreement is?
The agreements are bent to protect fish and supply as much water to the ranching and farming communities as is conceivably possible. And we've done real-time work on those to, in conversations with Mr. Edwards and other now signees on these agreements that reflect that effort. And so we believe that they meet the standard as stated in the proposed regulation language, and that we would present that to the deputy director for his concurrence, and that these agreements would prevail and be honored by the board and the deputy director.
I just want to I guess, nail the hammer down, and that is, so participants in a voluntary program discussed with the fishery agencies and approved by the deputy director would not have to undergo additional curtailments that might be imposed by the board as a result of this regulation. And I'm looking for a simple yes, that is correct.
Yes, that is correct.
Thank you.
For the board.
Let me answer one question that you didn't ask yet. I'm normally hesitant to do that, but the voluntary cooperative solution aspect of the regulation certainly provides, under the circumstances that seem to be present in most cases already, one mechanism for complying with the regulation. But another situation where that was mentioned in some of the comments is where the amount of water that is specified in a specific number is not present. Well, one of the requirements for the curtailments to be issued, the practical requirements for a curtailment to be issued, is that the fish are actually present. So we're going to be monitoring this on a real-time basis, certainly with the help of the fisheries agencies. So if there is no water, we expect that the fish are not present. And if the fish are not present, or if there is so little water that the fish aren't present, then people won't be required to curtail. So this is not an on-off date range, meet these flows situation. There are a lot of situations in which we're going to be monitoring this on a real-time basis to make it happen realistically so that the water isn't being required when there's no benefit to fish. You're confused because it was a question you didn't ask.
No, I mean, it's not confusing. It's just, it's a kind of a trust us sort of regulation in a way.
It's an implementation mechanism that will allow the board to ensure that on the ground we'll be doing this in the way that it's set out to happen. Those are in addition to the voluntary cooperative agreements, but that's one of the many mechanisms built into here to allow diversion and use for water for the existing uses as often as is possible without causing the potential issues to the fish that were identified as the basis for the emergency regulation.
Right, so it's an attempt within a regulation to do what the cooperative agreements are trying to do too,
Yes.
in parallel.
One of several, yes.
And so I'm thinking of the example when there isn't water, it's running across the lava rock. That would not be a situation in which you would have the 30 something CFS flow having to be released unless there's enough water that the fish might make it over a riffle. They're there and they might make it.
Part of the unique situation that we're dealing with here is that there are not upstream diversion facilities to release water to do that. So what we're
Right.
dealing with here is having people curtail diversion so that water that's naturally available can remain in the stream to provide these minimum flows. So if the water's not there and the deputy director determines, probably with assistance from the fisheries agencies, that no fish can make any use of the water, then we wouldn't be curtailing people from use of that water. That's one of the mechanisms outside of the voluntary programs.
So, oh, sorry, go ahead.
Additionally, with the way we set up the flows in the regulation is we tried to identify a situation when we see the flows start to recede below the benefit of either being able to do a pulse flow or moving towards a trend where the base flows are going to not be met under natural conditions. So then we would trigger that pulse flow to try to get those fish that are in the system to move up prior to that happening. And then after that period of time, the hope would be that they move up and we would not need to do a further curtailment because they're no longer present in the lower watershed. The other point to make, just for clarification, is that there are no flow requirements in July, August, and September.
That's important.
So, okay now?
Yes.
I was just going to, the pulse flow and base flow, though, those would be met through the voluntary agreements. I mean, that's the whole point behind putting these agreements together so that they're not subject to the regulation. They're curtailing themselves through these voluntary agreements.
Correct.
Mm-hmm. So I know we have more witnesses, but I'm going to just throw this out there for food for thought in the meantime. I don't think there's an emergency in those situations. And so I just don't see for the areas, which is why I was asking so many questions to begin with, on antelope, if it's 100% of the participants or the diverters, and on mill, 70% plus 13, 83%, and there's, negotiations underway with the remaining diverters. With those agreements in place, there does not seem to be an emergency. So I'm just throwing that out there. Deer Creek, I think, is different. So I know we have more commenters, but I just wanted to throw that out there for folks to think about in the meantime.
And this would be a question for you, Dee Dee. Are you thinking that, as we were told, there could be those who've made these agreements can back out of the agreements at any moment. So the minute they backed out, would you say there is an emergency?
Well, that's why I was asking the question, you know, how many, what's the percentage? You know, do you have to have 100% in order to say there's no longer an emergency? Is there sort of you know, a little gray area? What if you have the 83%? I really don't know. I don't think, I mean, that's part of the problem with, you know, going through this quickly. It's hard to make a determination. But my gut is telling me that if you have 100% on one creek, that there is not any there's no imminent threat. It would be imminent if everybody says, we don't like this anymore, forget about it. Then I would agree with you, it's a different situation if everybody walks away. What if 50% of them walk away? I really don't know. It's hard to tell. It'd be nice to have something ready to go, some sort of backstop ready to go in our back pockets in the event that that happens. But it just seems to me, looking at what would be required in order to move forward for an emergency, regulation is an imminent threat. I mean, looking at the government code, you have to have an imminent threat tied to, you know, not the whole state of California, but focusing in on you know, each creek individually. So those are just some of my thoughts. I mean, maybe I'll feel differently as we go through, but I just thought I'd bring it up for, you know, give folks a heads up.
Good. Interesting.
Tony Francois.
Good afternoon, Chair and members. Tony Francois with the Pacific Legal Foundation. I've got a short written comment letter which I'd like to offer for the record. It's an original in 9 copies. And then I'll just summarize 3 main points from the letter. One, we agree with the comments that have been made so far about the use of a process like this for making reasonable use and waste determinations. A particular point about that is that most of these water rights, whether they're adjudicated or the subject of board permits and licenses, either this board or the courts have already determined that those uses are reasonable and not a waste. And so that reduces the board's decision today simply to the decision that there are preferred uses, and where those preferred uses are jeopardized, what you previously determined to be reasonable is now not. And we don't view that as within the historic and legal definition of a determination of reasonable use. Related to that point is a concern that the proper venue for dealing with curtailment of any adjudicated rights is actually in the decree court that adjudicated those rights. In most cases, those courts have entered permanent injunctions and have retained continuing jurisdiction to supervise those rights. Some of these streams may even have water masters appointed. And where the board is concerned about time and responding to an emergency condition, you may actually find that you can get faster action by addressing this in the court. The courts are accustomed to dealing with emergencies in different ways than regulatory agencies are. Second point, we agree with the disagreement that this should be done as a quasi-legislative process. The board's current statutory and regulatory approach to these matters requires quasi-adjudicatory proceedings that protect the due process rights of water right holders. We have a serious concern that converting that existing process to a quasi-legislative emergency regulation has due process implications of its own. In addition, we would point out that every decision that the regulations vest in the deputy director will be a quasi-adjudicatory decision as to particular water rights, curtailment or not, of particular water rights. And the proposed regulation contains, that we can find, no due process protections. There's not even an apparent right to appeal to the board from a decision of the deputy director under the proposed regulation. And then finally, we are very concerned about the provision to reprioritize water rights. You've heard several comments about that already. The point that we would bring out on that, in our view, you risk incurring takings liability by acting outside of the priority system for curtailing water rights. Completely separate from whether or not the board has the statutory and constitutional authority to curtail and making a sufficient finding to do that. The violation of the priority system essentially results in senior rights being curtailed without compensation in favor of junior rights. Those are our comments. If there's any questions, we're happy to answer them, and thank you for the opportunity.
Thank you. Kurt Wilbur. We have three more, and then we have Tim and Manazian.
My name is Kirk Wilbur. I'm the Director of Government Relations at the California Cattlemen's Association. I appreciate the opportunity to address you on this issue today. A number of our members are rather concerned about this, especially those in Tehama County, but our other members are also concerned about the precedential value of this emergency regulation. CCA is adamantly opposed to the adoption of the proposed emergency regulation for Mills, Antelope, and Deer Creeks. First, the emergency regulation has provided CCA, and more importantly, its affected members, with little time to fully digest the effect that this regulation will have on their ranching operations. Ranchers that divert under riparian rights, pre-1914 appropriative rights, or receive water from mutual water districts depend on this water to irrigate pastures and to provide drinking water for their livestock. Both of these uses are considered beneficial under existing California law and are given the same preference as other recognized uses, including fisheries. Ranchers have been hard hit by the ongoing drought that we've discussed today, and many declare it to be the worst drought that they have experienced in their lifetimes. It is estimated that nearly 20% of California's cow herd has been sold or lost as a result of this drought. Cuts to water within the Mill, Antelope, and Deer Creeks watersheds will land another severe blow to those who have struggled to maintain the remnants of their herd caused by what could now be the lack of irrigated pasture to carry cattle through until the winter. The regulation documentation suggests that Tehama County will take a hit of $14.2 million to their property tax roll solely for pasture if the regulation is put into effect. While this figure represents a large financial burden for the county, it does not account for the millions that will be lost by individual family farmers and ranchers who will ultimately suffer the most due to the loss of this production, or to the consequent economic impacts in the local community. CCA also questions the interpretation by the Water Board to implement the recent drought legislation signed by the governor as it relates to riparian, adjudication, and pre-1914 appropriative rights. While the Water Board does have the authority to curtail unreasonable use, the proposed regulation seems to suggest that only water for fish is a reasonable or beneficial use. This is contradictory to California water law and sets a dangerous precedent relative to the board's interpretation of the public trust doctrine and California water law. The regulation also accounts for voluntary programs as a means to offset the impacts of the regulation. While some have sought to seek cover under the terms of the conditions provided by NOAA and the Department of Fish and Wildlife, the Voluntary Drought Initiative has not been perceived by our members as a coercive act, whereas this regulation certainly would be perceived as coercive. CCA and its members certainly prefer the voluntary approach. Finally, CCA also believes that the adoption of this emergency regulation today will circumvent our members' due process rights. Any curtailment in use of historical water rights should go through a thorough hearing process and allow impacted water users the opportunity, as afforded to them under the law, to appropriately plead their case before you. As such, CCA requests that you do not adopt the regulation today and that you continue discussions with impacted stakeholders to determine what actions can legally be taken to reduce the impact of the drought for both our fisheries and our agricultural producers. Thank you.
Thank you. Jack Rice.
Good afternoon. Jack Rice with the California Farm Bureau. Thank you, members of the board, for the opportunity to weigh in. This obviously is an important issue, and it's going to affect a lot of folks, but both in these watersheds and then as a matter of precedence. And I have to address the timing issue. It's been said before, but for the individuals that are out there and are going to actually be using the water, this all came at once. You know, within a matter of days, they got something from the agency saying we want to work with you, and something from the water board saying we're going to shut off your water rights. And when you're an individual, you don't have an environmental compliance department that you can shuffle those documents to ascertain what is the most prudent approach to take. And so I don't know how you deal with that, but it's something that I think should, as a matter of equity, be addressed. One of the things that is most important, and we submitted a letter, but I want to summarize our comments, is just, when I read it, I'm not sure that what they're asking for the fish is itself reasonable. And here's why. First, the issue of temperatures, which came up earlier, and this is the first time it always seemed like we're being blamed for too warm of temperatures. There's a number that is quite readily identifiable. This is the first time I've seen there's some flexibility, but I think that's progress because that's probably realistic. At the same time, does that mean that 80-degree water, 20 CFS of 80-degree water is going to be dumped down Mill Creek when that can be used to benefit fish? The language of the regulations indicate that it will be required, because as it says full flow without diversion. So 50 CFS or full flow without diversion, so irrespective of it. Now we've heard here that there is in fact some discretion on the part of the deputy director, but that discretion is absolute. So it is a trust us situation. And I'm not sure that's appropriate given what's on the other side of this scale. And when going back to the fisheries issue, you know, we have that bell curve of when the fish show up in the system, and the recovery plan identifies the peak is in June 15th. For some reason, this says they're going to go till June 30th. So when we're talking about it, I'll take one step back. The draft resolution says that these flows are necessary to prevent extirpation. But catching the last few fish at the tail end of the bell curve is not going to extirpate the species. So are we talking about extirpation of a species or preservation of every last fish, like a take avoidance scenario? And I think that's an important thing to consider, and I'm not sure where this comes in. But it does matter when you're balancing the harm. 80-degree water, a bunch of it going down to help one fish that may or may not ever make it up. What's our standard? Fish presence is the standard, so apparently that means one fish. Going back to the discretion, that's a significant challenge simply because of the fact there are no sideboards on that discretion. Even for the voluntary agreements, it says if the deputy thinks these voluntary agreements achieve, they may authorize them. There's no guarantee, so they may decide not to, apparently. We don't know where the ball is. What are our standards? What's on the other side of it? And that's very troubling for individuals who are trying to figure out how do we work together and how do we deal with this really major threat that's coming at us at the same time. Finally, the necessity, going to these, actually not finally, there's a couple more, I'll try to be fast, but going to the necessity of it, they've got a long history of working with the agencies, and it's not clear what the emergency is in every one of these watersheds. Why is this necessary? And is it necessary? Now, as a side note, it might make sense from the outside to come up with a clever encouragement combined with this voluntary opportunity, but that's really hard when you're the person on the ground that's affected by it. And that seems to be a common theme, but that affects individuals in a much different way, and I would ask that be considered. The voluntary, one of the items about these voluntary local efforts is I don't think the language is flexible enough. This is assuming that it goes forward. The actual language is not flexible enough because it doesn't, when you read it, it doesn't say that if nymphs and Fish and Wildlife like it, it's okay. It says that if it achieves the purposes of this regulation. May I have a couple more minutes? If it achieves the purposes of this regulation, then it will go. Well, the purposes of the regulation are flow targets. And so there, it doesn't say that if it saves fish or helps fish or reasonably helps fish, it says the purpose of the regulation. So once again, that goes to the sideboards of the discretion that's provided to the deputy director. The last topic is just due process, the timing, the fact that this is going to impact vested property rights, that nobody knows where and how or what standards the deputy is going to use in exercising the discretion that's going to have that effect on those water rights. And the justification, and the justification given was that the current system is cumbersome. And I realized that was, you know, that's the same thing, rationale used to adopt the Patriot Act, and it does make some sense when you have this huge threat out there. You're really worried about protecting it. The Patriot Act argument might work, or it might make sense, or it might not. Depends on where you come down on that, I guess. But in this case, we're talking about that tail end of the bell curve again. We're not talking about extirpating the entire species, as I understand it. And they would know because maybe none of the fish have shown up yet, or maybe most of them have. And to me, that's a huge issue, because that means there's a big difference. If you're going to shut off water rights for 3 weeks, to maybe save the 3 fish that are hanging out at the bottom for whatever reason, is that reasonable? So thank you very much.
Thank you. Darrell Mullins.
My name's Darrell Mullins. I'm General Manager of Las Molinas Mutual Water. I'm not an attorney. I think it's been pretty well voiced, a lot of our concerns from a diverter standpoint. Economically, I think we've voiced our concerns through other presenters. This regulation comes on the back of a really dry winter, which a lot of the cattlemen have had to feed all winter, and the late rains, the feed weren't there, so that's kind of on top of everything else. Mm-hmm. It's a real interesting problem with the fish. Las Molinas Mutual Water Company has been exercising cooperative agreements since 1990 for the preservation of the fish on the creek, and I've worked voluntarily with Fish and Wildlife to preserve these fish and to assist in pulse flows, and have a agreement was signed in 2007 with Fish and Wildlife Service, ourselves, the Las Molinas Mutual, and the Mill Creek Conservancy and the Department of Water Resources, in a cooperative effort to meet the flow needs and concerns to meet the fish. And so in my instance, this new arrangement is a little more restrictive and a little less participatory on our part, because we had a week to look at it and try and decide whether it would fit for us. It was almost like a duck and cover move for us, you know, unfortunately, because we do have a long history of working cooperatively with the agencies. Part of this program, just last year with the out-migrants, they acoustic tagged 50 out-migrating fish. All 50 of them made it to the mouth of Mill Creek. One of them made it to the San Francisco Golden Gate Bridge. So that tells us that possibly the problem with the fish population could be outside the watershed. It could be in the ocean. It could be in the fact that there's a lot of largemouth bass down around Colusa that love to eat salmon. So we think there may be some other issues rather than just Mill Creek. We understand they have to get the spawning grounds in order to repopulate and generate. And I would just say that we have an agreement in place, and we've had agreements in place, and that no emergency exists on our watershed. And I could take questions on Mill Creek.
Thank you. Thank you for coming. Next speaker is Candace Owens.
Good afternoon. My name's Candace Owens, and I appreciate the opportunity to talk to you. My family has owned and operated a ranch on Milk Creek since 1909. I have great compassion for the fish in the land. Most of what I was going to say has been said today. But in a nutshell, the economic impact for my ranch, for me, and my neighbors would be horrendous after what we've been through this winter. I am here to urge you to abandon this emergency curtailment. I just I can't say it any more plain than that. I think it needs to be reviewed, rewritten if need be, hopefully not. And I also would like to suggest that people go back and review the historical data of the fish migration prior to Shasta Dam being built. I think you'd find that very interesting for the spring run. And also flushing down 80-degree water is an invitation to death for those little fish. Thank you.
Thank you. Now we have Paul Manazian and Tim O'Laughlin, and I think you all are, I have two cards, so you've got two opportunities, but I believe you're cooperating on the presentation. And
sure, we are. Do you want to take an afternoon break right now for 5 minutes?
Sure.
Does that
And
make sense?
wha-
And then what I was thinking, and you can contemplate this, and you don't have to respond now, it may be helpful since NOAA and CDFW are here, and I don't know if you want me to ask the questions to you and you ask them the questions, but there's some specific questions and answers, and I'm pretty sure they have the information handy, which will kind of help put this, what I'm trying to do is to put this into context for you, both in a little picture and in a big picture. And so what I would propose to do is, if that's agreeable, we ask a few questions. I have a couple questions for your staff as well, and then we'll give our presentation. It'll take about 20 minutes. And then, how much time do you need, Paul?
I think that's a good estimate.
Yeah.
Maybe another 10 minutes.
Yeah, so we should probably, I think our presentation, if we took a break now, probably we'd be done within an hour with the Q&A and everything else for the two major diverters.
that sounds good to me. Let's come back at 10 of 4.
Okay, thank you.
Up here is the right one to talk about these cooperative agreements. So they're the people at the end of the line. Good. Okay. So look for them. Thanks.
Yes. What are you looking for in terms of a transcript for, I mean, in terms of delivery times?
Let's see, they're done today, and then I'm going to hear from them. I don't know. See, it's two things.
Or you might not need one.
Well, no, we're going to need one.
Okay.
I'm pretty sure we're going to need one. So they could adopt this today, okay, in which case I probably need a transcript within 5 to 7 days. If they don't adopt it today, then it's going to push it out because I have to be in court no later than June 2nd. So when they put the graph up, they said it was going to go into effect June 2nd.
Yeah.
So we're on May 20th today. So we got about, what, 13 days? So, but the schedule might slip if they don't adopt it today and come back later.
Okay.
So probably, what works for you? 5, 7 days, is that kind of in the ballpark?
Yeah, we can do 7,
Yeah.
I think.
Okay.
Yeah.
Let me know.
Okay.
Okay, let's just do that, and we'll talk after this and make
That's
sure.
fine.
Okay.
Yeah, I'll just make
Perfect.
sure that
Thank you.
I'm with you on that, and we'll get it together.
Okay.
They give you the presentation clicker. Should I grab it?
Oh, they have not. Hi, Barbara. there? Perfect. We're going to need that. Thank you. You know how to work one of those? Kind of technical. Back and forward? Yeah. And you can, if you want, you can sit there. Sit right next to Paul. Like old times again, huh? Good, huh? Hey, Les, I'm good. How are you doing? Love this stuff. I don't know if I have a big enough fruit basket for you guys this year, though. No, we don't need any. We don't need any.
Okay, it's 10 minutes till, let's see. Tim, I need some I completely missed a half hour of what you asked for. I thought you said it would be 20 to 30 minutes. Is that not correct for?
I think between Paul and I, we could probably get done between 4:30 and 4:45. Ballpark. Pretty easily.
Almost an hour?
Almost an hour. I think we can cut it less, depending on how the questions go, but probably close to an hour.
And so, can you be as efficient as possible about listing your questions to the various?
They're very short.
Okay. We'll put 30 minutes on, and then let's reevaluate at that point, because I really, we are.
I appreciate
we really do want to hear from you, and
I do.
this,
Okay, so
okay. Go
the
ahead.
first question, actually, my clients wanted to know this, so I'm going to ask this question coming out of the chute and then get to more substantive questions later. And this is directed to state board staff. When did staff start working on the draft rules and regulations with NOAA or CDFW?
I don't know that this is very relevant in terms of helping me understand and make a decision on this issue. I'd rather that the questions be directed to the substance of the proposed regulation, Mr. O'Loughlin.
Yeah, well,
I understand that you're trying to establish a record for future action, but what's uppermost, at least in my mind, is having the substantive questions and answer with respect to what's being proposed in order to make a decision on this item.
Well, it goes to the question of quote-unquote emergency. So, I mean, if you're, one of the interesting things about where this conundrum is, where we're at right now, is if your staff's been working on these regulations for 2+ months or more with CDFW and NIMS, I don't know how long it's been, then, you know, is it really an emergency at now? And we get 5 days due process to respond. So it goes to a very central point of the whole question of an emergency. So I think it's, I wouldn't ask it, but it's entirely applicable to the substance of the issue that we're talking about today.
Well,
And
my
it's a
con-
simple
my
answer. They
concern
can say
stands.
they
My con-
started.
I understand that these are arguments you will be making at some point before a different court, but that is not the court, or this is not the setting in order to do it. I'm most interested, again, in questions with regards to the specific content of the regulations in order for me to make a decision on this item. Content.
I understand your concern.
And Mr. O'Loughlin, I don't mean for this to be a back and forth between us.
No, I know. So I want a ruling, and I'll move on. If they say don't answer the question, I'll ask the next question.
Well, we're not doing, sorry, you're running the meeting. We're not doing an adjudicatory thing, so you can make
No, I
your
know.
case or make your argument, as many people
Can't hear
made.
you.
Many people made the case about due process and what they think would be more fair, what their concerns are. I would encourage you, because we're trying to figure out what to do,
Okay,
to just make the arguments to us, grab our hearts, grab our minds, as opposed to sort of an artificial
Well, let me-
Q&A, which you see you're getting kind of an irritated reaction to, and that isn't really great advocacy.
And really, Ms.
So it'd be better just make the case, and then maybe
Well,
we'll
no,
be
I'm-
more
so let me
amenable
ask you
later.
And let me add, I mean, maybe make your case is not quite the term I was
make
used.
the arguments that we should be
Okay,
listening
so-
to. The folks who came earlier were excellent.
Okay, so let me change.
So-
Let me change the question then. Okay, so I have a specific question for Deer Creek. Okay, how many adult spring run have migrated up Deer Creek this year?
This year, we've reviewed data through May 12th, and this is a rough number, but approximately 700 fish.
Okay, so
entered.
now, would you agree that fish moving in operate on a bell curve? It starts out slowly, builds to a peak, and then descends down?
I would agree.
Okay, are you on the downward side of the bell curve?
I would agree.
Okay, so can you, in your professional opinion, try to tell the board in the next 2 weeks, 3 weeks, a month, how many spring run do you expect based on historic population runs that you've seen come into Deer Creek that we would expect to see in the next 2 to 4 weeks? Ballpark, if you can.
Ballpark up to 100 fish.
Okay, thank you. Now, on Mill Creek has spring run as well, correct?
Yes.
How many fish have shown up on Mill Creek? Adult spring run.
Approximately 250.
Butte Creek?
I do not have those numbers.
I'm sorry, I'm going to have to interrupt. I'm really uncomfortable with the direction this is going. You know, like the previous commenters, like you said, have all been excellent in that they raised their points, they put their points in the record. I'm not at all comfortable with this cross-examination. This is not a court proceeding. And what Mr. O'Loughlin seemed to be doing is deposing or cross-examining the staff, whether it be our staff or the fishery agency staff. And it is not at all helpful to me in terms of my ability and my understanding in acting on this issue. So I would request that Mr. O'Loughlin follow in the suits of the commenters before him and provide his comments to the board rather than asking specific questions of specific staff.
Well, if my understanding is correct, the hearing officer has already allowed me to ask questions. And if you want to go back and revisit that.
Actually, this is not a hearing, and therefore there is no official
Well,
hearing officer
it's a-
per se.
Well, you can do it any way I don't want to argue about this point, but the question is, I asked earlier, if this is a quasi-legislative process, you clearly have the discretion as a board to allow participants to ask questions. And you said yes, or the board did not say yes, the hearing officer said yes.
That's
Or the
correct.
vice chair said yes, okay? So, and if you don't want to do that, I think it's helpful though, Board Member Tam, because, so the reason I asked those 4 questions was to ask this next question because it's in your order.
You know, I would rather you just come straight to the point and say, well, this is my concern, rather than ask, question after question.
But-
Just get to the point and give
But-
me the point of your concern,
Yeah,
because
but
that
the
would be
point,
helpful
the
to me.
point is, NIMS and CDFW have information that we don't have. I think that information is information you need to have. You need to know how many fish this is going to affect. Does this affect the species? How it affects the species? We've talked about water temperatures already. We're going to show you some riffles. And they have the information. I mean, if they don't have the information, they can just say no. So I'll give you an example. So in your order, and this was the lead up to the question, it says the National Marine Fisheries has identified minimum flows necessary to prevent extirpation of those species in blah, blah, Deer Creek. So one of my questions, this is your proposed order that you might adopt. So leading up to that question was, does NIMS think, in their professional opinion, if these flows are not adopted, if spring run Chinook salmon would be extirpated in Deer Creek?
So I'm going to jump in real
No,
quick.
that's a good question.
That's a good question.
That's a good question. Just
got
ask
one.
that.
I get one. That's what I was going to. Those are called foundational questions leading to a question. Sorry.
You are
I know,
talking
but
to an
different
attorney, not
I
an
know we
attorney
are.
here, an engineer.
I know.
So ask the question and just get the information. You don't have to lead them down this routine. Answer, please.
Well, I think that it's beyond the scope of this discussion here to determine if it's going to lead to the extirpation of the species. I think from our perspective, there's still a potential to have significant harm to the species, and Mr. O'Loughlin is suggesting that only the peak of the run is the one that we need to protect, when in fact, if you apply the concepts of viable salmon populations, it recognizes that the full life history diversity and the expression of full life history diversity is important to maintain viable populations. And so the outside of the curve very much matters for maintaining life history diversity and probably genetic diversity, although that's probably a separate, more detailed discussion. But focusing right on the peak has been a flawed approach for salmon management in Deer Creek for a number of years, and it's resulted in flow conditions that have impaired the passage of fish on the outside bounds of that bell-shaped curve. And for example, in 2010, I believe it was the last week in June, 8% of the Deer Creek population was still holding downstream of the lower reach of Deer Creek below the Stanford Vina Dam and was killed because they weren't able to get past the fish ladders at the dam there. And so that 8%, if you're arguing that the 8% of the whole population that came up in the very last week of June doesn't matter, I would argue against that. It's important.
I would like to add, if I may. We're talking specifically about the timing of the adult fish, but the flows that are being asked for are discussed in the regulations were shown on the board and in the board in the staff presentation. And so it's not just the adult fish. This is also the same period of time when we have the tail end of the juvenile fish that are going on downstream. And we're not talking about 100 or 3 or a small number of fish. That is still a very significantly large portion, number of fish and a portion of the run. So it's that in combination with the adult fish. Those flows do multiple duties.
Yeah, but you don't, I mean, as far as I know, you don't count juvenile outmigrating omicas, correct? I mean, you don't know how many juvenile outmigrating omicas have passed through the system, are coming through the system, or anything else, do you?
Yeah, that's correct. The status of Omicus monitoring is below par.
Yeah,
It,
I just don't know. I mean, I don't mean to mince words, but when you say that it implies something. So can we agree to one word, though? Extirpation? Because doesn't extirpation have a specific scientific terminology? And is that applicable in regards to these flow requirements on Deer Creek?
I think our attorney is going to comment on that.
We can remove that language from the draft resolution.
Okay.
Right. Other than,
I'm sorry, but can I also just note that this is also regarding the steelhead run? So even though this year we're adopting the regulation, later in the year, if the drought continues, you know, I think the full steelhead run would potentially be impacted by the regulation. Just to explain a little bit why we felt like that was appropriate to have in,
October.
that's also equally appropriate to take out.
okay, so I just want to get a couple things clear. So in the rules and regs that were proffered, it says that the Deer Creek Irrigation Dam is an issue. So has that issue been resolved with the installation of the fish ladder? I'll let anybody answer that.
well, no, I'm not familiar enough with what the criteria for the fish ladder performance are. And I'm not certain if the flows that are, if without the flows that we've proposed would be suitable to get the fish up to the ladder to move over it. So it's hard to say if the
Part of
fish
the
ladder
issue.
itself
Right.
meets our goals.
It's not the ladder, it's the ability to get up the ladder.
That's correct.
Right.
The Department of Fish and Wildlife, in working with DCID staff, have installed a temporary fish ladder to help DCID with their obligation to pass fish at that structure, which has no fishway on it. And fish, this structure will benefit fish now that are coming up at the tail end of this run, and also into the fall when flows are projected to go even further reduced, and fish of all species and sizes will have an even more difficult time getting past that structure. That's the purpose of the fish ladder that was just installed today. It is really not on topic
Today.
with the discussion we're having now, which